Today I've been filming Sheffield Defend our juries as they led a silent vigil outside Sheffield Crown Court. The same thing has been happening at every Crown Court in England and Wales this week. So what's it all about? Juries are widely accepted to be the safeguard we all have against the tyrannical abuse of power by politicians, ministers and those in positions of authority in our courts. But following a pattern of jury acquittals of those exposing government dishonesty and corporate greed through direct action, judges in UK courtrooms are denying both defendants and jurors their rights by restricting what defendants can say in their trials and by limiting what jurors are allowed to hear. People have been sent to prison just for using the words climate change and fuel poverty in court, and banned from explaining their motivations to the jury. Defend our juries are members of the public who are upholding the law to ensure that everyone is informed that when on a jury you have an absolute right to acquit a defendant according to your conscience. This right has been enshrined in British law for centuries. But how can a jury apply their conscience to the evidence if they're prevented from hearing why a defendant did what they did? And how can they exercise a right if they don't know they've got it? There is a constitutional crisis taking place in our courts. As the government ramps up its programme of repression against all those who expose its dishonesty and corporate corruption, trials of those taking non-violent direct action are increasingly taking place in the Crown Court before a jury. The randomly selected members of the public who make up our juries are proving to be the state's Achilles heel. In the last few years, juries have acquitted, among others, those who have toppled the statue of the slave trader Edward Colston into Bristol Harbour, those that defaced Shell's headquarters in response to Shell's lies and crimes about climate change, those that blocked the M4 motorway to demand the government insulate social housing during an energy crisis, those that targeted Elbit, who manufactured the drones who kill the Palestinians, and those that intervened to prevent violent deportations to Jamaica. Jury trial is supremely important to the British public, and it would be politically impossible for the government to remove it. So the courts have surreptitiously sought to undermine the substance of jury trial, while preserving its appearance. In particular, the courts are banning those engaged in campaigns of political resistance from explaining their motivations and beliefs to the jury. They're disallowing or ignoring relevant evidence and witnesses, including expert testimony, as to the government's failure to act on the scientific advice. They're telling the jury that motives, even if articulated, are irrelevant and must be ignored. They're sending people to prison for saying climate change or fuel poverty in court. They're banning references to a jury's right to acquit a defendant as a matter of conscience. They're arresting and referring for prosecution those who highlight the right of jurors to make decisions on their conscience. They're directing the jury that defences such as necessity, proportionality or reasonable excuse are not available. And they're threatening to move to judge-only trials. When Trudy Warner, a retired social worker, was moved by the repressive measures which threatened this principle to take a stand, holding up a sign communicating the jury's right to make decisions of conscience, she was arrested and sent to the Old Bailey, where the same message is displayed. The Solicitor General, Michael Tomlinson KC, has informed Trudy that he is minded to apply for her committal to prison for doing this. So today, we are all saying, we are Trudy Warner, and we are holding up this same sign.